The first part of this program will be led by Professor Robin Fretwell Wilson. Professor Wilson is a Roger and Stephanie Jocelyn Professor of Law at University of Illinois, the College of Law, where she directs the Family Law and Policy Program and the Epstein Health Law and Policy Program. She specializes in family law and health law, and her research and teaching interests also include biomedical ethics, law and religion, children and violence, law and science. Professor Wilson will honor us with her lecture on the subject of relational parenting, parenthood by agreement, and other new approaches to parentage in national law. Professor Robin, Professor Wilson.
Thank you very much. Can you hear me at the back? Is it okay? Can you hear me? Perfect. First, it's such a privilege to be here, and congratulations to Hezi on the book. I say only with some chagrin as to Michael Broidy that Cambridge is clearly the best publisher in the entire world. I think that's undisputed. Some might say Oxford, which recently published Michael's book, but I think we should say Cambridge, which is publishing my new book, as well as two others that I have. I also want to say that it's not accurate to say that Hezi, I hope it's okay that I say Hezi, that Hezi has contributed only to Jewish family law. I think that actually underestimates the importance of the book. It is a contribution to the family law of the world. And it's sort of with that perspective in mind that I want to give some impressions from the United States. So I'm going to start the stopwatch. Hezi rightly points out that there is a pressure to embrace broadened understandings of parentage in the world, as well as here in Israel. And that's coming from essentially three places. One, non-traditional families, and I'll come back to that in a moment, but we can split them further into families that are same-sex persons, and then even further in another piece of the world into families that largely map onto, at least in the United States, minority communities. And by that I mean communities where we are likely to see kin relationships. In other words, a grandparent, a sister, a cousin, or someone raising children on behalf of the one or both biological parents. Now, Hezi wants to use an idea of determining legal parenthood by agreement, or DLBPA, which is hard to say, so I may just say agreement, as the most appropriate, he says, flexible and just doctrine for resolving the competing concerns when we have newer forms of family. Now, in the United States, we are also struggling with what I call, in a new chapter for the Oxford Handbook on Children in the Law, what I call relational parentage. And a relational parent is basically someone who receives rights in a child as a result of their relationship to another, the adult's relationship to the parent of the child. In other words, the rights are flowing through the legal parent of the child and that person's relationship to the child. Now, that could be a partner, so a non-marital or even a marital stepfather, for example. It could be a grandparent whose rights in the child are flowing through the legal parent, or someone else who has been entrusted by the legal parent to care for that child, again, flowing through the legal parent. And I call that relational parenthood. Now, through most of history, we have known who a child's parents were. It was the child's biological mother and her married partner, who we assumed to be the biological father. I see you shaking your head. That's not always true. Now, Hezi reason, in fact, by the way, in the United States, only 92% of men are the biological parent of the child that their wife gives birth to. So let me say that another way. 8% of those women were cheating. okay? But the law, as he says, assumed and recognized both parents as the child's parents because he says both have invested in the conceived child through their sort of contribution biologically. Now that's not true for the 8% of men who were cuckolded, obviously. And then he says, and because they made these biological contributions, then both of them became the child's functional or sociological parents. And then Hezi says, with that biology and that sociology, the law catches up and simply has to designate or officially recognize both of them as the parents of the resulting child. Now, over time, he says, in your system as well as mine, we added adopted parents, which I think is terrific. I'm an adopted child. It very much informs my views of some of these issues. And so your civil and your religious law have long recognized that there can be non-biological parents who are the most wonderful parents that we could possibly have for those particular children. Now, add to all of this the dramatic rise in the different kinds of families that we have seen. And they test this narrow conception, adoption and biology and marital presumption as the only family. And they raise profound questions about who is a parent. So what does it mean to be a parent? Parents get to decide all kinds of things about their children, the education, which school, their care, their upbringing, whether they'll be raised in the faith or not raised in the faith. But they also get to do something that in property law we talk about as sort of the classic bundle of sticks. And one of the most important bundles of sticks is to say who does not have access to your child. In fact, in the United States, that's given constitutional import. The state cannot tell a legal adoptive or biological parent that someone has to be able to see their child unless there are extraordinary circumstances or that parent is unfit, warranting the state to enter into what would otherwise be a protected domain. So the idea of parenthood is given such constitutional import that when we start to recognize a new group that's outside of that original box, we're potentially talking about encroaching on the rights of the folks that we clearly recognize as the legal parents of children. Now, with duties or with obligations, often with rights, often come obligations. And here's an important disconnect with some of these newer forms of family. They're frequently giving the, let's say, social parent of a child rights to see that child without saying that they have to provide any child support whatsoever. And one of my profound problems with this newer category is that if you're going to recognize rights in a child, you should recognize obligations too, especially when you're stepping over in what will be in the stereotypical case, mothers raising their children. I think it's deeply offensive to mothers to say that other folks are going to be involved in your child's life, but they don't even have to pay child support. I'll come back to that in just a moment. So for some scale of the issue, I think we have to recognize the importance of Obergefell, which was our same-sex marriage decision. There were many people in the United States who were locked outside of marriage. And because they were same-gendered couples, they could not, through biology alone, without assisted conception, take advantage of the narrow box that we started with. And that puts tremendous pressure on that box, as he points out all across his book. But in the United States, we've had other challenges too. So we've had the rise of cohabitation and non-marital childbearing, and it simply cannot be understated. So for example, across most of the United States, 46% of all children are born outside of marriage. In some communities, that's over 70%, over 7 in 10 children born outside of marriage. Clearly, marriage cannot do all the work in deciding which adults are going to be connected to their children. So it can't do all of that work alone. Now, more directly relevant here, and to my concern about relational parentage as a doctrine, is the fact that 7.2 million American households, 6.1% of all U.S. households, are composed of an unmarried couple in which one of them, well, are composed of unmarried couples. Half of that number, approximately 3 million people, are cohabiting, where they are either married or unmarried, and only the child is the biological child of one, or the offspring of one. So we're talking about millions of families in America that don't fit in the original narrow box, and that's putting pressure on our notions of parentage. And then finally, in the United States, we have 1 in 10 children, which is staggering, living with a grandparent or having a relational, a person who's going to have a relational interest in the child as a result of being a parent, of the legal parent of the child. And that's an incredible number. In 1 in 100 households, fully 1% of American households in America, the grandparent is the only caregiver for that child. And so big demographic changes that we've had in our society, delayed marriage, for example, single parent households, longer life expectancies have all sort of come together to say, well, geez, shouldn't the grandparent who is raising that child, certainly they have rights as a parent in the child so that they can direct the child's upbringing. Now, like Israel, we also have lots of children who are born of assisted conception, which has been very important not only to LGBT couples, but to couples like my parents who were infertile, and as a result of that, decided to adopt. Today, they might have used assisted conception. Now, I'm less concerned in the United States about the children that are born of assisted conception, because we have legal doctrines that I think map pretty well to the problem. In other words, if you and I were infertile and wanted to have a child, we could go have a healthcare provider assist us with that, and we're both involved in the formation of that child, right? The sort of bringing of the child into the world at the very beginning of the child's life. And more than likely, the child is raised in a household by us, and you are holding out as the child's parent. And so the law can be really pretty sure about everybody's intention when there's a parent by estoppel, because but for both of those parents, that child would not have come into being. Much harder when we start talking about relational parents, particularly as Hezi says in his book, someone who already has a child, who then, long after the child and the mother, usually in the stereotypical case, have lived together, gets together with a new person. So a boyfriend or a married partner. Now, in that instance, I think we need to look very, very hard at some of the doctrines for creating parenthood. And I'm just going to make a number of observations and try to flesh them out as much as I can. In one sense, I think we have to be concerned that I think Hezi's right that we're no longer conceptualizing the entire family based on a spousal relationship. He believes that that's now going to place the relational person's relationship to the child on a firmer ground that is much more durable and long-standing. I don't doubt that, but I do wonder whether that relationship would accord with the interests of the legal or the biological parent to decide who stays in the child's life or doesn't. Now, one big point to take away here is that we never have to talk about this when both parties agree. We're only talking about this when the parties don't agree. So if you and I had a child that we raised for a period of time together because it was my biological or adoptive child, and we agree you should stay in the life, all fine. No one's doubting that you can stay in that child's life and hopefully pay child support, right? Where the trouble comes in is where these two parties see these things differently after the fact. And there, I think I might give much more weight to the interests of the biological/legal parent than at least some of the broad move in the law in the United States is willing to do. Now, I am not doubting that relational parents can have loving, bonded investments in children, can make important contributions to children. I do not want to be heard as saying that, like, for example, biological parents and only biological parents can do that. Adoptive parents, my adoptive parents, have changed the entire arc of my life. So this is not about the primacy of biology. It is instead about the primacy of the legal parent to decide who is involved in the child's life. And so I'll just take that point from there. Now, I also want to leap off a little bit more than to Hezzy's specific proposals to something that has just happened in the United States, which is the Uniform Parentage Act being revised in 2017. In our system, there are two very influential law reform bodies. One is the American Law Institute, which in 2000 tried to make some of these changes. Almost completely failed, largely because of a group of academics led by me who suggested to judges that some of this was without grounds. Not only this particular issue, but they wanted, for example, to get rid of the best interest of the child standard, which in 49 of 50 jurisdictions in the United States actually drove what was decided about children at the time, and still does in 48. And so they tried to do things that were very, very disruptive of the existing body of law. The Uniform Parentage Act, I haven't looked at nearly enough to decide whether it's on that scale, but it is promulgated by the Uniform Law Commission. This is a set of usually legislators who come together. They do not attempt to restate the law. In other words, it's not their purpose to take the law of West Virginia and the law of Maryland and try to figure out, well, how can we make them work better together, or to restate, clean up the law. Instead, they take it unto themselves to suggest that places where the law can be better drafted and better founded. So they take it as their job to actually to advance the law. Now, I do believe that we need a coherent doctrine for relational parenting, that in the United States, that we have a splintering of approaches which go under a number of headings. A de facto parent, which is basically someone who shared caretaking for a child, or in loco parentis. In that instance, it would be somebody who stood in the shoes of a parent as to that child, which could be just payment of child support and not caretaking, or some combination of things. Or psychological parenthood in the United States and some states, which would be the child, you know, this person can stay in the child's life if the child saw that person as a parent, which is not quite the same yet again. Or parenthood by estoppel, where everybody agrees and this person holds themselves out as the child's parent. Now, those are four very, very different conceptions of what should make someone a parent. Now, importantly, and I think maybe most importantly in some ways, as to both the UPA and the ALI proposals, they don't always require child support. Now, that is beyond fathomable for me. You're going to tell me that this person stays in my child's life, even on a small scale, visitation, decision-making with me for my child, and doesn't pay a dime. That's just staggering. It's a staggering encroachment on the constitutional rights of the parent without putting in the other position someone who has the full-on obligations of a parent. Now, Hezzy, I'm not quite sure whether he, completely endorses that particular view, but I think it's a stunning thing to allow in the law. Now, to be clear, the Uniform Parentage Act actually only allows the person, this person, to execute a particular kind of new parent called a de facto parent. So a mother could not use a de facto parent doctrine under the Uniform Parentage Act to make you pay child support. I can't drag him to the parenting table because I've relied on him for child support, or I made sunk investments, bought a bigger house because I thought he was in my life, or he was going to help pay for the kid. I can't use it in that way. But he can say that he'll stay in my child's life and then use the process to make me explain why he should not. Now, under the Uniform Parentage Act, there were in all of this decision-making in the United States, there were two big stages. The first is called standing. Step-parents, for example, in the United States, did not have standing in many, many jurisdictions for a long time and still don't today. And that meant that if even we were married and he acts badly or doesn't matter why, and we divorce, I don't have to defend a claim of parentage by him. Now and then there was a second stage. So once you cleared standing, then there were substantive tests. The Uniform Parentage Act creates a test with 7 elements for whether or not this person should stay in the child's life and to what degree. Does that mean visitation? Does that mean decision making? Does that mean child support? Does that mean full-on parentage in every single regard? And it seems to leave lots of discretion to judges to decide among those things. Where I think at least as a minimum, if you're getting rights, you should have to pay child support, period. Now, much of what we've done in the United States in expanding these doctrines has been to assume that people who want to stay in a child's life are good guys, that they're good influences on the child's life. So I'll just synopsize 3 recent cases where we have had the de facto parent claim made by people that to me are patently bad men. Bad men. So for example, in Moreau, this is a case where a man texted the mother of her own children. Okay, so this guy had lived with the children, had lived with mom for 10 years, lived with the oldest child for 6, lived with the youngest child for 3. And then he texts the mother, I promise you for the rest of my life, I will find my girls and I will never stop ever. He showed up at her house at 2 a.m. in the morning twice, banging on the door loudly. She has no cell phone, no way to exit the house. The kids are home and he's known to have a gun. She gets a restraining order after the first night. He shows up the next night at 2 a.m. and the police are there to serve the restraining order on the bad guy. And then as she gets a restraining order to keep him out of her life and her children's life, he goes to the family court and says, I'm a de facto parent. And guess what? He qualifies. He would normally qualify, except for a technical problem in the law, which is that Vermont law, because they had not married. Oh, okay, I'm happy with that. I'll just tell you my 3 scary stories and then be done. But Vermont law had not given a statutory grounds out of which this court could do equity and give him rights. Had she married him, she would not have been able to keep him out of her kids' lives. So standing and these doctrines of parentage do important work to keep bad people out of children's lives. Now, you could just say, don't worry about standing. The judges will get it right. They'll figure out that he's a bad guy, right? It's possible. But I think before we rush to allow more and more people in children's lives over the express wishes of their legal parent, we should stop and think about whether it's always good risks or bad risks. Second case, which actually should just scare women who are interested in cohabiting. I think we need to put a warning label on cohabiting that reads something like this. This guy can be in your life 11 months, and make claims on your child. And this happened in a case called Pitts versus Moore, which came out of Maine. The mother lived with a boyfriend off and on for 8 years. Then she has an affair with another man who's in the military. Then she comes back to the boyfriend. She's with the boyfriend for 11 months while she basically gives birth to this child. This guy is then in their life for 11 more months and break up and then 1 more month. All in. He's in that kid's life 12 months. He claims to be a de facto parent. He's violent. She gets a restraining order which says that he cannot see the child unless supervised, which he did on a, quote, mostly consistent basis. And she doesn't obviously want the kid to be seen, it's an infant, by a guy who was abusive, who's under a restraining order. You can imagine why. The court cleaves to its prior test, which had basically said that you're a de facto parent if you have a permanent, unequivocal, committed, and responsible relationship. The trial court gave him rights to visit, no duty to pay child support, no decision-making for that child. The court ends up saying that we will recognize a de facto parent, we're sticking by our test, and then it basically remands so that she has to prove that this guy staying in the kid's life would actually prove harmful to the child. So the burden gets shifted. And then one last case, which came out of Massachusetts. It's the case of a little girl named Haley Poultry. She was bludgeoned into a coma by her mother, her adoptive mother's married partner, so what would be a stepfather, Jason Strickland. She had, when she reported to the hospital in Westfield, Massachusetts, she had old and new bruises, open and new cuts, several apparent weeping burns, and a subdural hematoma. She was in a coma. Jason Strickland, her legal mother and her mother's mother end up committing suicide, in a double suicide. And the only legal parent left standing, or only person that could claim parenthood left standing, was Jason Strickland. And Massachusetts had adopted the definition for de facto parent that the American Law Institute had established, which required equal caretaking by the two partners, implied consent by the legal parent to that agreement, right? And basically that was it for the test. In the court, in the Massachusetts Supreme Judicial Court, which is in Massachusetts, is the highest court, it said to think of Jason Strickland as a de facto parent with the right to make decisions for Haley is just completely unthinkable, and I'll end on this note. They said to recognize him as a de facto parent in order that he could participate in her decision making so that he would beat a rat, right, for murder. In order to do that is unthinkable, and in these circumstances would mount to an illogical and unprincipled perversion of the doctrine. And they said that our cases in the past have focused exclusively on the existence of a significant pre-existing relationship, a standard that presumes a bond between the child and that de facto parent would be above all loving and nurturing. And they literally had to read a protective device back into this test in order to avoid such an unthinkable result. Now, that's not to say that what any of us want to do to recognize relational parents is wrong. Probably isn't. But we have to be incredibly careful with the tests that we're constructing, or we're going to leave children worse off, not better. Thank you.